think so.
Hello, everyone. I just wanted to let you know we have muted your lines. However, you can unmute your lines to ask questions by hitting star 6. Once you have finished asking your question, please hit star 6 again to mute your line. Mr. Adam Smith and Mr. Matt Livesay will be presenting today. Adam is a fellow of the tax section and the tax visiting assistant professor at UF Law, where he teaches individual income tax, corporate tax, and federal tax research. Before joining the UF Law faculty, Adam worked for the IRS Office of Chief Counsel in Jacksonville, where he represented the Commissioner in Tax Court and advised the IRS on procedural and substantive tax matters. Adam is also a licensed CPA with more than 4 years of public accounting experience in audit and real estate tax. Matt is a tax associate at Barnett Bolt, located in Tampa. Matt concentrates his practice in the areas of federal income taxation, estate planning, and probate and trust administration. He earned his JD from and is currently an LLM candidate at the University of Florida 11 College of Law and has a bachelor's in accounting from FSU. I'm very glad to hear them speak today, and with that, Mr. Smith and Mr. Livesay, you can take the lead.
Yeah. Thank you so much, Julie.
Yes, thank you.
So, hope everybody's doing well. I'll give you actually, why don't I give you the course code right now, and then I'll repeat that course code again at the end of the hour. So the course code is 1701386N. 1701386N. Okay, so basically, Matt and I are going to give this presentation on involving some what we see as highly significant ethics issues in tax law, particularly considering where our environment is currently. We've had, last year the Panama Papers and the document leaks, and the prevalence of the offshore voluntary disclosure program, and there's been some public skepticism about tax planning. We've all, I know that we talked a little bit about it for those who were there at the economic substance meeting back in May last year, but this is something that we want to address to protect our professional reputation, both as members of the tax section and the tax bar in Florida, but also nationally and internationally. So what we're going to do is discuss sort of tax services in general, noting the hybrid nature of what we do as tax lawyers. And the nice thing about this presentation is it really relates to all different areas of tax law, regardless of whether you practice more along the lines of estate planning, or if you plan sophisticated multinational M&A transactions, reorgs and spin-offs, immigration planning, pre-immigration planning, that sort of thing. All of this comes into play, as well as in tax controversy practice and general tax practice. So, and also for those attorneys, and particularly for those attorneys out there who are practicing with an accounting firm. So I think it's a global issue that we really wanted to address. Now, there is a hybrid nature in tax services in the sense that pretty much anything that we do either relates to or ends up in one way, shape, or form on a tax return. And there's always some compliance element to a tax service. But we also know, as lawyers and some as CPAs as well, that confidentiality is really a critical value creation mechanism in tax practice. In other words, we want to encourage our clients to be forthright and frank with us and to feel the benefit of confidentiality so that they are encouraged to divulge all of the facts and that the lawyer or the tax advisor can appropriately and prudently advise them on the risks associated with a certain position or structuring a transaction a certain way, and evaluate alternatives. What Matt and I have noticed through our research is that there's what we call a labyrinth of perplexing decisions where courts have moved in the direction of trying to negate traditional protections over confidential information, and that they have fashioned some rules and some overly broad exceptions that basically swallow up the rule of attorney-client privilege and work product doctrine, and, in our opinion, contravene the core principles of the legal profession. That is advocacy, serving as an advocate for your client, and representation of a client in an adversarial system that we have. What we're going to do is I'll give you the roadmap. I'm going to talk a little bit about attorney-client privilege and work product doctrine in general, and then Matt's going to go ahead and talk about the waiver doctrine, the common interest doctrine that relates to waiver, the tax preparation exception, and an extension of that exception to what the Seventh Circuit has called dual-purpose documents, or the dual-purpose doctrine. And then I'll get into some recent cases that we think reject this trend. Matt will then discuss Covell, and then we'll handle some takeaways. Now, our presentation isn't necessarily going to follow directly with the outline that you have in the materials. That's an outline that I've used for other presentations on this issue. But we do have an article coming out in the tax bulletin. It's going to be a series of 3 articles that go into a little bit more detail and discuss in a little bit more detail the issues that we're going to describe in this presentation. So let's talk a little bit about attorney-client privilege. So we'll turn first to attorney-client privilege. So attorney-client privilege, it's an area of federal common law when we're dealing with federal tax. Now, I will note that if you're a state and local tax lawyer, then state common law, attorney-client privilege rules will apply, but the basic elements are any communication made between privileged persons in confidence for the purpose of facilitating the rendition of legal services. Anything that meets those 4 elements should be protected under attorney-client privilege. Again, the idea is that we protect the communications to encourage our clients to be forthright and frank and allow the lawyer or the tax advisor to adequately assess the risks associated under the facts and to prudently advise. Now, fairly recently, Congress enacted Section 7525 of the Code, which extends to, quote-unquote, federally authorized tax practitioners, which is defined in the regs and Circular 230, and these practitioners include CPAs, enrolled agents, and for those practitioners, we will also find that the attorney-client privilege will attach to tax advice if it is rendered in a non-criminal or non-tax shelter matter. So that only relates to attorney-client privilege, not work product doctrine. Now, work product doctrine is a little bit different. Work product doctrine really focuses on the concept of fairness and convenience in an adversarial proceeding. So unlike the attorney-client privilege, which promotes communication between the attorney and the client by protecting the confidences in those communications, the work product doctrine is more of a qualified protection. Its goal is to preserve a zone of privacy so that the lawyer can prepare and develop legal theories and strategies with an eye toward litigation, and do so without worrying about intrusion by adversaries. In other words, that the IRS won't be able to get a hold of the lawyer or advisor's legal analysis, thoughts and conclusions and opinions. The trick here with work product doctrine, you'll see the phrase come up. The work product doctrine, what it does is it protects from discovery for admission as evidence documents and tangible items, as well as intangible items, prepared in anticipation of litigation by or for a party or by or for that party's representative. So, unlike attorney-client privilege, work product doctrine will bring in, under the privilege, other non-legal professionals, not just the attorney and client communications, but it will bring in non-lawyer professionals who prepare documents or other material if there is, what the rule says is in anticipation of litigation, and I'll talk in a second about a circuit split and how that's interpreted. What I do want to note is this rule is only codified in the federal rules under Rule 26B in the Federal Rules of Civil Procedure, because the real doctrine is announced in Hickman versus Taylor, and to the extent that Rule 26B-3 does not apply, because it only addresses documents and tangible things, Hickman's definition would extend that work product doctrine to intangible items such as thoughts or opinions, mental impressions, and so those could be in the form of, email conversations, or you can imagine a situation where the IRS is soliciting testimony about what was said. So those will be protected as well if they fall within the purview of, quote unquote, in anticipation of litigation. The idea is that the court in Hickman was really concerned about not forcing a lawyer to have to repeat or write out information that's developed through the discovery process. Okay, so what does in anticipation of litigation mean? And this is where things get a tad bit hairy. Hello? Oh, sorry, that was somebody joining the call, I think. We have a circuit split with regard to the meaning or the interpretation of in anticipation of litigation. The First Circuit uses the narrowest test, and it limits work product protection to documents prepared, quote unquote, for use in litigation. A good example of this one, or the application of this rule, is the Textron case. And that in that case, the First Circuit held that work product doctrine did not protect from an IRS summons tax accrual work papers that the corporate taxpayers' accounting staff prepared, and the court really reasoned that although the work papers were contemplating the possibility of litigation, so inevitably for audit purposes, the external auditors are going to consider the risk that a position is going to fail if challenged by the IRS. That's part of the disclosure on the financial statements. So looking at that, really, the taxpayer's argument there is, we were really, the auditor was really considering the prospect of litigation here. The court in Textron applied a very narrow test and said that these work papers are used to comply with financial reporting rules, not to strategize or defend a position in litigation with respect to the tax issues. So that's the narrowest test, and it only applies in the First Circuit. The Fifth Circuit, in a case that was after the Davis case, which it was a 1981 case, came after, by the way, the adoption of the 11th Circuit, by the 11th Circuit of all preceding Fifth Circuit decisions as binding precedent, that Bonner versus Pritchard case. So this is limited to the Fifth Circuit. It's somewhat of a broader view, and it protects documents if the quote-unquote primary motivating purpose behind the document's creation was to aid in possible future litigation. Again, that application, as far as we've seen, has only applied in the Fifth Circuit and not the 11th Circuit. The majority view that's been adopted by the 2nd, 3rd, 4th, 7th, 8th, and D.C. circuits is, luckily for us tax lawyers, the most expansive application, and protects a document if, in light of the nature, and I'm reading the quote, in light of the nature of the document and the factual situation in the particular case, the document can be fairly said to have been prepared or obtained because of the prospect of litigation. So that because of the prospect of litigation is significant. It recognizes that the work product doctrine is going to cover situations in which the attorney-client privilege does not. And I'll give an example in a second. But what I do want to note here with this circuit split is that we have the Golson rule in tax court, which says that the tax court is going to apply as precedent, as binding precedent, the rule of the circuit to which the case would be appealable. And so depending on where your taxpayer sits, a different rule might apply. For example, Fifth Circuit, if your taxpayer resides in the Fifth Circuit and petitions in the Fifth Circuit, that narrower primary motivating purpose test might apply. And this is something that you're going to want to think about if you're representing a taxpayer in a tax controversy matter. The tax court does recognize that work product is outside the scope of discovery in Rule 70B, but also takes this more expansive view, similar to the majority circuit courts. If you read the notes to Rule 70B, or the comments to Rule 70B of the tax court rules, the comments expressly reject certain exceptions to the work product doctrine that would otherwise require disclosure. And so some of these situations that might not qualify under the Fifth Circuit's interpretation or some other exceptions might not apply in tax court. As far as the 9th, 10th, and 11th circuits, none of these circuits have ruled on the issue yet. The 11th Circuit, within the 11th Circuit, there's a split among the district courts as well, and I don't want to get too much into the circuit split because we have limited time, but I can provide those cases if somebody emails me and is interested. So let me just give you an example here. Let's say that as to how the circuit split is significant. And so let's say a company is contemplating a reorganization and retains an attorney because it recognizes that the transaction and its nature might prompt an IRS challenge. The attorney's tax opinion, which will likely include a discussion of relevant statutes, regulations, legislative history, prior judicial rulings, alternative theories, that sort of thing, recommendations for the structure, and often predictions about the likely outcome if challenged. Of course, with penalty defense, we have the substantial authority standard and more likely than not standards that we're all familiar with, right? That's going to show up in an opinion. So under that scenario, the work product doctrine is not going to necessarily protect these sorts of opinions if the primary motivating purpose test of the Fifth Circuit or the First Circuit's test, which is for use in litigation, certainly that narrow test, it's not going to apply. U.S. versus Edelman gives a really good example which is has substantially similar facts for this hypothetical, and in that case the district court applied the Fifth Circuit standard, so that case will actually illustrate to you how the conclusion is different depending on the interpretation of the rule that the court applies. With that, I'm going to turn the phone over now to Matt, who's going to talk a little bit about the waiver exception and common interest doctrine.
That's right. Okay. Thanks, Adam. So Adam did a great job talking about the fundamentals of attorney-client privilege and work product doctrine. I'm going to spend a little bit of time here discussing waiver of attorney-client privilege and work product doctrine and the common interest doctrine. So disclosure to a third party of information otherwise protected by the attorney-client privilege or work product doctrine may constitute waiver and negate any privilege or protection. Now, courts apply different analysis for waiver of both attorney-client privilege and work product doctrine, and voluntary disclosures waive the attorney-client privilege because disclosure is inconsistent with the attorney-client relationship. Now, contrastingly, voluntary disclosure waives work product protection only if, quote, such disclosure under the circumstances is inconsistent with the maintenance of secrecy from disclosing the party's adversarial interests. Now, once a party waives either attorney-client privilege or work product protection, that party is generally deemed to have surrendered the privilege or protection for all purposes and in all circumstances. A waiver of work product doctrine will apply to all non-opinion work product concerning the same subject matter. In other words, subject matter waiver. This waiver can occur accidentally, but courts have been reluctant to find complete waiver where the disclosure was clearly inadvertent. In a tax controversy setting, waiver occurs if the taxpayer places tax advice at issue by asserting a reasonable cause or reasonable basis affirmative defense to a penalty. Now, because these defenses waive both attorney-client privilege and work product doctrine, the tax advisor should carefully consider whether the circumstance warrants an intentional waiver.
Yeah, so that's a really important point that Matt's bringing up, which is, oftentimes in a tax controversy setting, we're concerned about a penalty defense, and so the question really arises: does it make sense? Looking at the numbers, running the numbers, does it make sense based on the amount of the penalty? Is it worth waiving both ACP, attorney-client privilege, and work product doctrine by asserting the defense? That's something that you need to consider.
Right. And then along with that, there are exceptions to the waiver rule, and in that is found the common interest doctrine. So what the common interest doctrine says is that if a party or representative discloses a document or information otherwise subject to either attorney-client privilege or work product doctrine protection, but the disclosure was made to further a common legal interest shared with the recipient, waiver does not occur. So this common interest doctrine applies only where parties undertake a joint effort with respect to a common legal interest. And the Second Circuit has made it clear that the common legal interest sufficiently includes common business, economic, or financial interests in the outcome of legal matter.
Right, and the common interest doctrine's really been at the forefront of recent case law, and so we're going to I'll discuss that when we talk about in a little bit when we talk about the developments in the case law and how those quietly reject some of these exceptions that we've been concerned about that have come out of the Seventh Circuit. Right,
exactly. So, and then pivoting back to waiver in and of itself, when relating these principles of waiver to tax practitioners, the tax preparation exception comes about, and it's a somewhat troubling exception for tax practitioners in the way of attorney-client privilege and work product doctrine. The basic rule of the tax preparation exception is that information transmitted for the purpose of preparation of a tax return, even though transmitted to an attorney, is not privileged information. Now, courts justify this preparation exception by applying, like we said, the principles of waiver, or by reasoning that tax preparation is not the practice of law. While tax return preparation does involve legal advice, attorney-client privilege does not attach because there is either no expectation of confidentiality or a waiver of the privilege because simply filing the return constitutes public disclosure. And that's usually the opinion that has come out, or some variation in all circuits in the U.S. So, for example, in the Seventh Circuit, the seminal case of U.S. v. Lawless, the circuit held that, I think, for a letter from the executor of an estate of a law firm that also handled the estate tax return contained a letter with, quote, a great deal of financial information and also a handwritten note on an envelope to the law firm from the client. And the circuit court held that they were not protected under attorney-client privilege or work product doctrine. Now, the reasoning behind this was that the documents contained information which would be relevant to and utilized in the estate tax return, which makes sense. But what's astonishing about this case is that the court didn't actually review the return or consider whether the preparer, in fact, used those documents. And the implication, then, is that regardless of whether the information actually appears on a filed return, this transmitted information in underlying detail is not actually protected.
Now, yeah, and this is a really important point here. So, as lawyers, tax lawyers that are practicing at law firms, we generally know, or hopefully know, that it is really important to avoid preparing a return wherever possible. As you'll see, and we'll talk a little bit, and Matt's going to get into this dual-purpose doctrine, but under Lawless, which is the seminal case on the issue, basically, if you prepare a return, you've blown privilege for all of your legal advice related to any subject matter pertaining to that return. I recently had this come up. It's not to say that you should never prepare a return. It depends on your client. I had this come up with a client in a request for abatement controversy issue recently, and I put together a memorandum of law, submitted it to the revenue officer who pushed it on up in the IRS, And ultimately, the IRS agreed with our position and granted a $300,000 abatement, except for one thing. To process the abatement, the revenue officer required me to file a return. So I spoke with a colleague of mine who's an international tax CPA, return preparer in South Florida, and he wanted to charge my client $1,000 to basically take numbers that I had already come up with and throw them on a return. At the end of the day, I had a discussion with my client, and it made sense that I would prepare the return, and saved my client about $1,400 so in fees. So that may be a relevant consideration, but we do recommend wherever possible that you not prepare a return if you are giving legal advice.
And try to segregate the two hats that you could potentially be wearing. So I guess with that, I'll move on to the dual purpose doctrine. And really an extension of the tax preparation exception. What we found in our research to be the most alarming rule that's come out of, again, the Seventh Circuit for tax practitioners related to these privileged communications and documents is what's known as the dual purpose doctrine. And this came out of a case called United States versus Frederick. And in Frederick, the tax attorney in the matter, who was also named Frederick, served both as the client's tax legal advisor and tax return preparer. Now, Frederick objected to an IRS summons on the grounds of privilege with respect to the draft returns that he had prepared and also supporting schedules and worksheets containing the financial data. What complicated the issue is that when Frederick took on the clients, he was already aware of pending litigation in an IRS investigation. Though the court acknowledged that these documents contained some of Frederick's own thinking, in other words, opinion work product, they still held that the documents which Frederick did create in connection with preparation of tax returns and also in anticipation of litigation was not privileged or protected under work product doctrine or the attorney-client privilege. The court proceeded to state in its opinion that by using Frederick as both a lawyer and a tax return preparer, clients run the risk that their attorney's legal cogitations born out of legal representation would become discoverable. Ultimately, they fashioned this, what's now known as a dual-purpose document, which is boiled down to or distilled into one document prepared for both the use in preparation of return and for litigation, which is clearly a legal service. And they held that is no longer privileged.
So this is really troubling because what Frederick does is it creates a very liberal expansion of the tax preparation exception. And not to say that we haven't been able to identify a case where a court's taken Frederick and brought it and expanded it out so far to try to get into its possession like planning documents for an estate plan or an opinion for planning a transaction. But if courts continue to liberally apply the tax return preparation exception in this manner, and we're going to show you how, we can see that they could potentially draw a link and make the argument that pretty much anything you do is discoverable.
Right, yeah, they can make the argument that if you liberally construe Frederick, anything that an attorney does could technically be an advancement of a tax return preparation, and everything that is prepared and all documents and information used could be within the government's reach. So what we found is an example in a Treasury reg, which is a bit alarming for day-to-day practice for a tax practitioner, and I'll just read the example here. It's pretty quick.
It's in 301-7701-15
B2, Romanet 2, Example 1.
Yeah.
So in that example, we have attorney A, who's an attorney in a law firm, and he provides legal advice to a large corporate taxpayer regarding a completed corporate transaction. The advice provided by A is directly relevant to determination of an entry on taxpayer's return, and this advice leads to positions or entries that constitute a substantial portion of the return. A, however, does not actually prepare the return himself or any portion of the return and is not the signing tax return preparer. Nonetheless, A is considered a non-signing tax return preparer. So the extension of this example tethered to a Frederick liberal interpretation could say that even if you're not ending up providing any compliance work, because you provided advice, you're a non-signing preparer, and therefore all of your information is now subject to discovery.
Under the tax preparation exception,
right?
So that had to do with the ethical rules and preparer liability. That's where that reg's found. But if you look at preparer liability, I don't think it's too far of a leap for the government to make to say, look, the regs themselves say that you're a non-signing preparer. How can you say that you haven't engaged in the preparation of a tax return, or that the documents you prepared didn't relate to the preparation of a tax return? Okay, so with that,
I think we're gonna move on to the quiet rejection of Frederick in and of itself.
Okay, so that's the bad news. Okay, so we gave you the bad news first. The good
news
there
is some relief.
And I do want to point out, so most of to the large extent, the line of cases supporting this narrow view that with the tax return preparation exception and the expansion of that exception into dual purpose documents, almost all of it comes out of the Seventh Circuit, and we haven't seen too many district courts or courts in other circuits follow that per se, but that doesn't mean, that could just be because these cases haven't been litigated yet. Frederick was a 1999 case, and so, that's where we're at. It's somewhat limited to the Seventh Circuit, but again, think about the Golson rule and think about where your case might be appealable to if you end up in tax court, right?
Right. So for now, practicing in Florida, you should be okay. This hasn't permeated all the way down to the 11th Circuit, but the potential is there, is really the concern.
And so what we'll do now is talk a little bit about a recent trend that we've identified with cases dating back to 2010 and then going forward up until last year. And for those of you who attended the meeting in July, I gave a rundown of some of these cases at that meeting, so this might be redundant, but I think it supports the argument that we're not in a terrible of a position as it may have just seemed going through the tax preparation exception and its expansion. So the first case that I want to talk about is U.S. versus Deloitte, so that case came up fairly recently in the D.C. District Court. It's a 2010 case, and in that case, the corporation brought an action against the IRS with respect to adjustments to partnership returns filed by two partnerships that a corporation owned and two of its wholly owned subsidiaries. The government, so this is a refund action, government files a motion to compel the production of three documents. One of them is a draft memorandum prepared by the independent auditor. The second one is a flow chart prepared by the corporation's employees. And the third one is a tax opinion prepared by the corporation's outside counsel. So here you see where some of your work might come into play if you're practicing at a law firm, and certainly if you're practicing at an accounting firm. The D.C. District Court denies the motion, and the government appeals. So taxpayer wins at the district court level, and the case goes up on appeal, and so it's up in the D.C. Circuit. The D.C. Circuit states that a document can contain protected work product even though it serves multiple purposes, and this is a quote, so long as the material was prepared because of the prospect of litigation appealed. So here we have the D.C. Circuit coming out, and at least in the work product doctrine context, which Frederick also dealt with, work product doctrine, the court comes out and says the document can serve two purposes, both legal purpose and some other purpose, maybe financial for the purposes of financial statement disclosure or tax return preparation, and still remain protected under the work product doctrine. It's an explicit rejection, in our opinion, of the dual purpose doctrine, at least in the context of the work product doctrine. So it's a significant case in that respect. It is only a district court opinion. It's not. It is a D.C. appellate court opinion, and it's limited to that circuit, the D.C. Circuit. But we think, again, this is a trend starting to reject the Seventh Circuit's interpretation of the rules. The next case that came up last year was Scheffler. And in Scheffler, the taxpayer was a German auto parts supplier that wanted to buy an interest in a German target. the target had made a tender offer, and to finance the acquisition, Scheffler borrowed 11 billion in euros from a consortium of banks. And this was just 2 days before the tender offer expires, the financial markets collapse.
Yeah, I think Lehman Brothers fell 2 days after.
Yeah, so the case actually notes that Lehman went down 2 days before the tender offer expired. And so what happens is the value of the shares plummet, but under German law, Scheffler, the taxpayer, is required or obligated to purchase almost all of the shares of the German sub, or the target. And it becomes the not-so-proud owner of 90% of the target, and that value is almost pretty much substantially worthless. So taxpayer solvency is on the line here, because the asset that it had just paid a ton of money for is worth virtually nothing, and you have a consortium of banks who loan the money to finance the transaction, who stand in a position where one of their large borrowers is about to default on a major loan, multi-billion euro loan. So what happens? They look to do a financial restructuring and refinance and try to come up with a way that the money can be paid back under mutually agreeable terms, and they want to achieve certain tax efficiencies in the restructuring transaction. We won't get into the substance of it, but some of you are familiar with how you can handle debt workouts in a tax-efficient manner. So that's what's going on. The taxpayer retains Ernst & Young to advise on the transaction's tax implications and to try and help structure this thing. So EY prepares, as it would in the course of its practice, prepares a memo that contains a few items. It contains a detailed analysis of the federal tax issues that are implicated by the transaction, assertions that there is no law clearly on point, language that suggests that this is not a clear-cut situation. It says, although not free from doubt, but our opinion is that the better view is, and it may be argued, terms like that, and basically suggesting what the IRS could or could not argue, and then offered some arguments and counter-arguments that the taxpayer could make if the IRS were to challenge the appropriate treatment of the refinancing and restructuring transaction. Well, the consortium of banks was interested in the tax consequences of this transaction because if, as it turned out, if the government was successful in its challenge of the transaction, the taxpayer would have faced a substantial tax liability, which would have impeded its ability to repay the loans. So again, placing both parties in a financial distress situation, all pertaining to the IRS recognizing and accepting the tax position taken with regard to the refinancing and restructuring. So the IRS issues a summons seeking production of the memo, and the taxpayer moves to quash the summons, arguing that the memo is protected under Section 7525, the practitioner-client privilege. EY falls under that privilege, and so that would extend attorney-client privilege to the memo, and also makes an argument on the grounds that it's protected under the work product doctrine. Lower court finds for the taxpayer. Finds for the government, and then the case gets appealed up to the Second Circuit. So the Second Circuit reverses and finds for the taxpayer, holding that the taxpayer, and so really the heart of the issue here was by sharing that Ernst & Young memo with the consortium of banks, did the taxpayer waive both attorney-client privilege and work product doctrine protection? On appeal, the Second Circuit holds that the taxpayer did not waive either attorney-client privilege or work product doctrine by sharing the opinion with the consortium because these banks had a common legal interest in the outcome of the resulting tax contract. Now, at the heart of the government's argument was they did share a common interest. The taxpayer did share a common interest with the consortium, but it was a business and financial and economic interest. It was not a legal interest. Why? The consortium was not a party to the tax dispute. Only the taxpayer was. Well, the Second Circuit rejected that argument and recognizes that you can have both a business interest in the outcome of litigation and what would be considered a common legal interest. So the common interest exception theoretically applies to common legal interests, but this case recognizes that it can be both a business purpose, a business interest, as long as it's an interest in the outcome of the litigation, as long as there is that litigation aspect to it, that litigation or adversarial proceeding flavor to the end result. Another key point here is that, some folks have said that 75-25, the practitioner privilege, may not really do anything to protect documents prepared by CPA firms, such as opinion letters. And with this case, we know that 75-25 is alive and well. One final key point about this Scheffler case is that the court notes that the in anticipation of litigation standard broadens as the complexity and size of the transaction increases, which also increases the probability of IRS scrutiny. So although we know we can't advise clients based on the audit lottery, we can say that with respect to work product doctrine protection, we can consider the probability that the IRS will scrutinize the transaction. In other words, does this transaction raise a red flag for IRS scrutiny? And if that's the case, the work product doctrine will expand and attach to the advice given. So that's basically Scheffler. The final case that we wanted to talk about real briefly before we get into Covell, and I want to save Matt substantial time for that. This is Sanmina, or at least 5 or 6 minutes for that. Sanmina also came out last year. The IRS in that case challenged the corporation's $503 million worthless stock deduction. At the administrative level, the taxpayer attempts to substantiate the deduction by submitting a valuation report memorandum that had been drafted by outside counsel. That report indicated that for its valuation, outside counsel relied on 2 separate internal memoranda prepared by the taxpayer's in-house tax department. And the taxpayer distributed those 2 memoranda to its internal tax team as well as to its outside CPA firms. The IRS issues a summons requesting production of the 2 internal memo, and the taxpayer, of course, claims privilege under both attorney-client privilege and work product doctrine protection. So the court holds that both of these memoranda are protected by attorney-client privilege and work product doctrine, reasoning that the memo constitutes tax advice from lawyers to their client as opposed to a mere formulation of numbers in preparation of a tax return. Remember, these related to the valuation of the stock so that the client could take that or justify or substantiate that $503 million deduction. So this was considered tax advice by the court, even though it related to numbers that are eventually placed on a tax return. Again, getting to that dual-purpose document and tax preparation exception. The court also found that the taxpayer doesn't waive privilege as to the subject matter by producing the final memo to the IRS. So just because it produced that final memorandum on the valuation report, which in court which referenced these two other in-house memos, that did not constitute waiver. So some notable points here: both the drafters in this case served in the capacity of attorney, the in-house counsel, and at least one of the memos had been labeled confidential work product, written on each page of the memo, which is going to get to our best practices and recommendations, and they contain some detailed explanations and analyses. So basically what we're saying here is that Sanmina's holding adds momentum to the pendulum shift away from the Seventh Circuit's interpretation and provides more protection.
Right. I guess it's time to move on to Covell.
Yeah, we're going to finish up with Covell and just a couple of quick takeaways.
Yeah, and I'll try to go through this quickly. So I think many that have called in are familiar with what are called Covell letters, and that springs from the famous 1961 case up in the Second Circuit, which produced the Covell Doctrine, which is another important exception to the general rule that disclosure to third parties waives this attorney-client privilege. So at issue in Covell was the fact that the IRS was investigating the taxpayer's alleged federal income tax violations. The law firm that represented the taxpayer employed and directly supervised an in-house CPA who was named Covell, and Covell was a former IRS agent and accountant. Now, under subpoena, Covell did admit to receiving statements from clients' assets and liability statements, but when the IRS further pressed him about the purpose of receiving these documents, Covell flat out refused to answer and used his privilege as grounds for refusing to answer. So the lower court judge held him in contempt, actually sentenced him to 1 year's imprisonment, and denied him bail. So once that was appealed, the Second Circuit reversed and held that attorney-client privilege extends to communications shared with an accountant who is employed by the attorney, not the client, and if the communication is incident to the attorney's legal advice. The opinion, if you've read it, it's heavy on analogy and likens the accountant in-house to a law firm as merely a language interpreter, right? That there are so many financial statements and crazy balance sheets and accountant lexicon that is hard for many attorneys to incorporate, so therefore, much like an interpreter would translate the language, an accountant is doing that for the numbers. So the court held that for attorney-client privilege to attach, the communication still must be in confidence and for the purpose of obtaining legal advice from the lawyer, not simply an accounting advice procedure from an accountant. So from Covell came what's now commonplace procedure for many tax practitioners, which is what I previously mentioned was employing Covell letters. So when you use Covell principles appropriately, an attorney can, without waiving ACP, engage CPAs or other non-lawyers who are professionals nonetheless through Covell arrangements to protect and insulate their client. Now, I'll give you an example. The attorney-client privilege attaches to a CPA's analysis of income generated by a client's previously undisclosed offshore accounts, which has been relevant recently. And this enables the attorney to assess the risks associated with the client's failure to file FBAR returns and properly advise the client on appropriate course of action. And this offshore voluntary disclosure programs are very topical today.
Yeah. And here's where it comes up is, to get your client into the OVDP program, oftentimes you have to file amended returns, but you also have to do a financial analysis to see whether your client's going to qualify for the program, because you have the $10,000. There's a $10,000 threshold with balances and things like that. So there is some financial analysis to be done, and so that's where we get into the recommendation here. And there's been we haven't seen any litigation on this, but we're going to offer what we think is a best practices approach here. We can't guarantee anything, but we want to give you some recommendations on how to mitigate the risk that the government can attach or can get a hold of these documents and get past privilege.
Right. Yeah, and I think that starts with, it's already in existence, but having strong Covell letters in place is really a best practice. Like we said, we don't really have case law expounding upon, what's appropriate or what is not when employing a quote, covolized attorney, but just ensuring the agreements state things like made in confidence for the purpose of obtaining legal advice from the lawyer, make sure that that is reduced to writing as being the scope of the accountant's role.
Yeah, I think with that, no, I mean, I think that pretty much sums up CoVel. You know, the question is, what do you do? So what we recommend, and there have been a few attorneys that do a lot of I don't do a whole lot of OVDP work. Actually, I do no OVDP work. Who I've spoke with, and they say what they've been doing is they covelize one accountant or CPA to handle the financial analysis, and they make sure that that CPA or non-lawyer accountant or financial professional had no history with the taxpayer preparing his returns. Again, a lot of this goes to this tax preparation exception, so we want to avoid that issue. So you have one covelized accountant or CPA, and you have a covel agreement with them. They perform the analysis and create a summary document that is then provided to a second CPA who you recommend that your client hires. Now, again, remember that with a covelized CPA, you, the lawyer, want to be the person engaging the CPA. Right. The engagement is between the lawyer and the accountant, and the accountant needs to be segregated almost like a Chinese wall from the client in this respect. The CPA is doing the work for you, the lawyer, to facilitate legal advice. The second CPA is non-covelized. We draw a curtain between them and make sure that his work is segregated and relates only to the return preparation. And we think, although it hasn't been tested, we think that that's the best practice to avoid possible discovery by the IRS under the waiver doctrine and the tax return preparation exception.
That's exactly right.
Yeah, so I think we're getting towards the end. A couple of takeaways to think about here. You know, we know that work product doctrine and attorney-client privilege are valuable tools for us as tax lawyers and tax advisors, but we need to understand the working knowledge and have a working knowledge of the interrelationships among all of these exceptions and view this body of law in a holistic way, understand it in a holistic way, which was the goal of this presentation, is to kind of lay out all of the issues that come up to the best of our ability. You can take steps to protect your advice. One thing you can do is, and we've seen it show up in courts analyses, is clearly indicating your documents and your materials an intent to preserve confidentiality. Label it as such, have confidentiality agreements in place, and indicate the purpose of the document. So if you are preparing something, a document because your client is contemplating a transaction and is concerned that the IRS is going to challenge the transaction, document that. Document that reasoning for preparing and for preparing the document and performing the work. With CoVel protection, like we just said, you know, you want to make sure that you have one, if possible, one CoVel protected CPA and one non-CoVel CPA, and do kind of what we just said.
And don't prepare the return yourself.
Don't prepare the return yourself if at all possible. I know that some practitioners do. They do 706s in the estate and gift world. If you do that, you know, you're planning.
There's still an argument that you could segregate your work appropriately, right? You could segregate between your work product doctrine that are legal cogitations of your own thinking, and then you could also wear the hat of a tax return preparer. However, from our research, it seems as though the IRS could really penetrate that type of arrangement far better than they could a covelized CPA.
Yeah, and I guess the final piece of advice is, you know, we have these tools. What we suggest is layer your privilege. Layer it with work product protection, attorney-client privilege protection, and if the circumstances warrant CoVel protection. So I think with that, we'll open the floor to questions.
Yeah.
Unless, Matt, you have anything to add, and we're at 12:53, so we got.
No, Sorcerer's Apprentice here. No, questions are great.
So yeah, go ahead and chime in. I guess you hit *6 to unmute. No questions.
Did that go?
Question?
Yeah.
Yeah, I'm looking for the handout materials for the seminar on the section of the Florida Bar's website. Not seeing it.
We're getting a lot of feedback. It's really difficult. Is there a way to? So whoever had that question, hit *6, and you should be able to unmute yourself.
I don't know. Maybe there's a technical difficulty.
Just a reminder, if you hit *6, you can unmute your line and then remute it by hitting *6 again.
Excellent course. Thank you very much. If you could read the CLE code again, that'd be appreciated.
Oh yeah, I'll go ahead and do that.
Thank you, guys.
It's 1701386N. That's 1701386N.
As in neighbor.
Well, all of them end in N.
It's like an M. You never know.
Question?
Yeah.
I'm on the tax section of Florida Bar's website, and I'm not seeing any particular CLE materials for this state course.
What I'll have you do is I'm going to give my secretary's email address out to everybody, and she will email it out if you send her an email right now. She has a copy of it.
Thank you.
It's L, her name's Lauren, L as in Lauren, Stuckey, STUCKI, at law.ufl.edu. So it's LSTUCKI at law.ufl.edu, and we'll also have the tax section put it up on the website. I'll make sure that that's fixed as well.
Can you please do a phonetic of the law.ufl or USL?
It's law, like LAW, dot UFL, like University of Florida Law, I guess, UFL.edu.
Hey, Adam?
Yeah.
Hi, guys. I had a question on Form 8275 in the context of what we're talking about. In terms of working with a CPA, do you have a best recommendation or best practices on how to go about sort of working with the 8275, saying, here's what we think the issues are, and then conveying that to the CPA on the return, or the CPA?
Well, okay, so the disclosure statement, the Form 8275 is a disclosure statement when you have a transaction that there might be some contrary authority, just for the other listeners out there. And I guess the question is, what do you do as far as attaining protection over is it with regard to your advice or to a CPA's analysis?
Well, the CPA would return the prepare the 8275.
Right.
My question would be discussing with the CPA what the attorney's analysis is of the issues and what to disclose.
Yeah.
Okay, so this is the issue.
I think this is the problem we run into with our research, is that it's unclear. Because for the third-party CPA, the non-collateralized CPA, to go ahead and prepare the return, if there's some ambiguity in the transaction itself, you need to be able to prepare that third-party CPA, but how much preparation or disclosure to that CPA then subjects everything that you've done to discovery.
Here's what I would do, okay, and this is just off the top of my head. As a lawyer, I would perform my legal analysis, but lay it out in two separate documents, okay? Right. The first document evaluating the alternatives and potential, bad facts, negative analysis, and the second disclosing the bare minimum that you have to reach your position.
Support for your position.
To support your position. And I would disclose the second document to the CPA and hope that establishes the level of protection. Again, a lot of this stuff hasn't been tested. I think that might mitigate your risk. I like to say mitigate your risk because we don't really know, but I think it'll protect it.
Thanks, guys.
Sure.
Good afternoon. Can you just reiterate your thoughts on preparing 709s or 706s in relation to the context of today's presentation, please?
You want to take that? I'll give that one to Matt because he's the estate and gift guy.
Yeah, I mean, it's concerning. I don't know that my position would change, right? Because ultimately you need to serve your client's best interests, and I don't know anybody that would be better in preparing a 706 or 709 than the attorney that's most intimate with the facts and the relationship. So much to what Adam said, there really is no clear distillation of the rule in the 11th Circuit, so I would proceed cautiously and try to segregate as much as you could with, again, the headings, confidential information, prepared in anticipation of litigation, those types of things, but the only alternative I can see is just like Adam, is perhaps preparing two separate memoranda, one that really explores and discusses the ambiguities in what's going on with an estate or a potential gift, and then provide to that third-party CPA your ultimate stance in getting you to the position that you're taking.
With the legal support, of course. Now,
right.
If you're taking a position and you have arguments for taking that position, if the government challenges it, you're going to use those arguments anyway, so you're going to waive privilege with respect to that. And what we're really concerned about with waiver or with any ability of the IRS to discover our thoughts and our legal analysis is, a lot of the time we'll sit down and we'll evaluate alternative transactions that may yield different results, and we'll ultimately conclude on a position to take. And so what I'm saying is I think the best approach, if you're not doing it already, because I know that some firms do, is to actually have two opinions or two memoranda. One would be the ultimate opinion letter that says, here's the position that we're going to take and here's why we're taking that position. And the other one says to the client, the privileged one is going to say, here are the alternatives that we've considered. Here's the legal analysis that applies.
Right.
And so that's your best bet. But again, depending on what circuit you're in and how the court, hopefully it doesn't get challenged by the IRS, but if it does, it depends on what circuit you're in. I think if you're in the Second Circuit and or one of the other circuits that have adopted a narrower view, well, the Fifth has a more expansive view, right, a middle view. So if you're in one of the circuits that take a narrower view on it or afford more protection, then you're in a better position. We don't know what the 11th Circuit's going to do. That's my best answer.
Yeah.
Thank you. I appreciate it.
No problem. Any other questions?
Thank you, guys.
Thank you.
Thanks
Is
so much.
Julie on the line? Nope. All right.
Well, thanks so much for calling in.
Yes,
is
I'm
that
still
Julie?
on the line. Yes.
Okay. So we just wanted to thank everybody for calling in and for the questions. And my email is posted up on the UF website if you just go in there and type in Adam J. Smith. But it's asmith@law.ufl.edu if you have any questions. And I can give you Matt's information as well. Do you want to?
Yeah, I check, if you want to send an email to Livesay, Livesay, @barnettbolt.com. That's usually my most frequently checked email. Yeah, and be happy to help with any concerns or questions you guys may have.
Thanks, guys.
Thank you.
Thank you.
Bye-bye.
All right, bye.